From the TWU Local 591 Union Hall, it's the Local 591 podcast with Local President Gary Schaible. Join Gary and his guests as they discuss topics that impact and affect the careers and lives of union members. Take it away, Gary.
All right, thanks, Tommy, for the introduction, and welcome back to the TW Local 591 podcast. Today, Vice President Pete Caruso is in. We're going to talk about an important topic of Article 32. Most of your rights as a member for representational purposes are in Article 32. That would be the old Article 29 in our old book. So Pete's here to kind of give you an overview on Article 32. So welcome to the podcast.
All right, thank you, Gary. First off, happy to be here, and very important information here to give out, because I feel that every member should know their rights. Every member should know this piece of information that we're going to give out here. So our JCBA Article 32, which is representation, gives the union the right to represent its members. Specifically, we'll be focused on familiarization of Article 32J and 32K in this podcast. Throughout the years, most of us who have been here a while, we're used to the term 29F from our past collective bargaining agreement, and it has always been sort of a negative term indicating that there's trouble evident. So a 29F protected us with the right to have a union rep present. So they just couldn't just start blasting questions without going through the process, right? So now the old 29F is now called the 32J. The JCBA Article 32, Paragraph J is a good thing for us, and perhaps, in a bad situation. It's important for all of our members to acknowledge that Article 32J is there to protect us, as well as it gives us the right to have union representation present in the event that the company conducts an investigation and is compelled to ask questions. Most of our members are not comfortable in a situation where you would be questioned and asked to provide a statement. That is why our 591 reps are there to provide guidance and protect your contractual rights.
Well, that's good info. So, 29F, just so we make it clear, that was our old contract. Some people referred to it as an F29. It was really Article 29, and sub-article was F, so that's 29F. So really what we're talking about here is the old 29F now becoming the new 32J.
Yeah, that's right.
So just a quick overview on what 32J or the old 29F is that's an enhanced version of your Weingarten rights. That's actually a Supreme Court ruling that the employees have a right to union representation when you're in an investigative interview. 32J, our old 29F, takes Weingarten to a step further by requiring the company to notify the employee, including probationary employees, of their right to union representation. In other words, the supervisor would have to notify you that you do have a right to representation versus somebody that doesn't have this language has to request that. So that's important to understand. With that said, Pete, when would the company require the use of a 32J?
Well, anytime the company asks you a question for the purpose of an investigation or asks you for a written statement, that's when the company will do a 32J. So when I say questions, it's not just any questions. It's not like the company would say, how was your coffee or how's the weather outside? That's not the type of questions. It's the question of where were you when the slide blew? Why were you out of your work area? Questions like that could potentially get you in a situation where you can get disciplined.
You mentioned the word investigative. Can you go a little deeper into investigative?
All right. The contract says investigation of any matter they choose to investigate, which may eventuate or lead to application of discipline or dismissal.
So that's for 32J. Just for clarity's sake, there is a different investigation, which is under 32L with corporate security. That would be for a different podcast. But in that, just understand you may request a peer witness. You not necessarily have the same rights as 32J of the requirement that I spoke to earlier, but just understand there is a difference between 32J, your operation management, and 32L, which is corporate security. Let's go back to 32J. So if a member of management approaches you and states that he or she needs to do an investigation and conduct a 32J to ask questions, what would a member do, or should a member do?
Well, that's a very good question, and it's probably one of the best questions. One thing to keep in mind that Article 32J in our JCBA is there to protect us as a union member. It affords us a right to have union reps present. So if you're approached by a member of management and they start asking you questions and possibly you ask to provide a statement, the very first action a member should take is not to say anything or give a statement until he or she has been afforded the right to have a union rep present.
Okay, and I hate even asking this, but there's people out there are probably going to wonder about this question, and I will tell you straight up, I don't condone this at all, is can a member choose not to have a union rep present?
Yes. Well, it's not recommended by the local union, and absolutely we don't recommend this. Article 32J also gives the option to refuse union representation, and the member of management will document the fact as well.
Okay, and then what would happen if a member of management says, listen, I'm just asking, no harm will come to you. I promise you, just provide me a statement. What should a member do?
First of all, and this situation has happened in the past, with the supervisor, maybe he knows you or he's your friend, and they come up to you to ask you questions, and they say, everything will be okay. And many times they're being directed to come do an investigation, or the questions are not coming from them. And the situation what you stated would be a violation of Article 32. All right, keep in mind they're asking you questions for a reason. If a member of management approaches you as if it's just a question or no big deal, the scenario, you can tell me anything. It's important that we don't fall for that. If they're asking you questions and or to provide a statement absent of 32J, it is because they're investigating something that could potentially get you in a situation where you or someone else could be facing discipline. It's your right to not answer questions until a formal 32J is assembled and you have had the time to confer with a union rep and know why the questions are being asked and to the reason for the investigation.
That's some good information, because you do hear that a lot with, the manager's my friend. No, he's not your friend, and unfortunately anything you say or do will be held against you when discipline comes. When a member is being asked questions by management in a 32J meeting, can a member refuse to answer the questions?
Well, now that you bring up the Miranda, anything will be held against you. Well, actually, the Fifth Amendment right to remain silent is your constitutional right in a court of law. However, you do not have that right in the workplace. When your employer asks you a question, you must answer the question truthful and to the best of your knowledge. If you choose to not answer the question, the company can terminate you for insubordination and failure to comply with an investigation.
So if I'm called in for an investigation, do I have time to confer with the union rep, also to know why the questions are being asked to me and the reason for the investigation? Really, in a 32J investigation, does the company have to let us know the reason why that's causing this meeting?
Well, absolutely. And that's covered under the next article, which is Article 32K in the JCBA, which protects our right to know the reason. The company must indicate the reason that causes the meeting and then provide an opportunity for the employee and his union rep to confer for a reasonable period of time. That's something that's very important, and we train our union reps how to handle this situation and how to get to the bottom of why we're being questioned in this 32J, and that gives us the opportunity to go outside, step out of the room, and confer and find out what's going on so we best know how to deal with the situation.
In this situation, can the company just issue discipline or terminate someone without a 32J?
No, we are protected in our contract. The company must abide by Article 32J before any discipline is administered and show just cause in a system board arbitration for termination as a result of the 32J investigation.
So I know we've kind of covered this, but I really want to stress about the importance of having a union rep present. Can you kind of take us through that?
Like I mentioned in the past, all of our stewards and chairmen have been trained on how to handle the 32J event. We constantly continue the training and how to better equip our reps to handle this. They've been trained on how to give guidance and ensure the company is abiding by your contractual rights. Article 32 also gives us the right to have the same number of reps present that management has, plus we're allowed one more to take notes. And also the notes is very important for us, especially in the termination where the company has to prove just cause for the termination in an arbitration, and we have to show otherwise to get you back to work.
One other area that we hear often is about attendance counseling. Would an attendance counseling be considered a 32J?
Absolutely. And attendance counseling could eventuate in discipline. Therefore, you have the right to have a union rep present, and Article 32J protects that. I would say it's not a good idea to go speak to your lost time administrator by yourself. Always get a union rep to go in with you. We also equip our union reps on how to handle this situation. You should treat it as anything you could say that we'll use against you. And also, you got to understand one thing with the attendance counseling is that this lost time administrator, he or she is there for a specific task on figuring out if your absence was necessary or not. And, they will ask you questions based on some things that our union reps would say, hey, hold on a second, you shouldn't be asking that, or we can give guidance to step outside of the room and such. So it's important not to go in alone.
No, that's some very good advice. I think we've covered the subject pretty well. Is there anything else I'm missing here, or any closing statements?
I would ask all of our members to familiarize themselves with Article 32 of the contract. Never be afraid of being silent until a union rep is provided for you. Never be intimidated to not contact your union rep. We're here to represent you, and we will be in your corner in the event you will need it. The 591 e-board has committed to continue training to provide our reps with all the tools they need to best represent all of our members.
Well said. I want to thank Pete for coming in and talking today on this important subject. I do hope everybody takes his advice. Thanks, Pete, for coming in.
Thank you for having me.
And as always, if there's any other subjects that you'd like covered by a podcast, please let us know at info@local591.com. I want to thank everybody for listening, and most of all, please stay safe.
For more information about TWU Local 591, go to local591.com. To comment on this or any of our podcasts, email us at info@local591.com. You can listen, download, and stream episodes of Local 591 Podcast on iTunes, Google Podcasts, your favorite Android podcaster, or your RSS feed-enabled browser. Local 591 Podcast episodes are also available to stream and download from our website, local591podcast.com/podcast. Music provided under license by pond5.com. The Local 591 Podcast is produced and engineered by Tommy Engel.